I now would like to invite Professor Neri. Professor Neri, can you hear us, please?
Yes, very well.
Welcome, Professor. Thank you very much for agreeing to address us. Professor Neri will be talking to us on the subject of Security Council, international peace and security and the sea, the evolution of Security Council maritime resolutions. Professor Neri, you have the floor.
Thank you so much for giving me the opportunity to be with you, even though from technological point of view. Thank you for your kind invitation. I would like to thank, of course, the Ministry of Foreign Affairs and the Korean Society of International Law for the invitation. I wanted to start by saying that, sorry about that, by saying that I'm kind of sad not to be with you today in person, but I'm grateful for the opportunity to talk about a very dear topic to me. So I would like first to make introductory comments on the peaceful use of the sea and what UNCLOS is actually containing on this matter. Then, because it is the issue of the conference, the assessment of UNCLOS in that area and what kind of effectiveness do we have. And last, for the introduction, the recourse to UN Security Council. So to begin with, the peaceful use of the sea is a general principle established by UNCLOS. The preamble is recognizing the principle. And we have, of course, the general obligation of Article 301 that states that in exercising their rights and performing their duties under this convention, state parties shall refrain from any threat or use of force against the territorial integrity or political independence of any state. So it's a very classical wording that the convention is using, referring, of course, to the United Nations Charter. And you also have in UNCLOS specific references to the peaceful uses of the sea, especially for certain zones like the ICs or the area, or for certain activities like marine scientific research. So in this area, UNCLOS is sometimes often limited, especially when it comes to maintaining international peace and security. Of course, it's not the main objective of UNCLOS. We have other institutions for that, but also, and this contributed to blur the difference between military and law enforcement activity that we just discussed with Professor Tanaka, but also in what concerned fighting crimes at sea. And we will see that Security Council is actually mixing the two notions. Yes, so maritime spaces are very much marked by illicit and dangerous activities, but these topics are not really addressed in details by the convention. We have, of course, new conventions that were adopted after that, but that's not the topic of today, because even with these conventions that were adopted to tackle specific problems of illegal conduct on the sea, the law of the sea sometimes reached its limits, and in these particular cases, the states have sometimes turned to Security Council to obtain new derogations in order to exercise enforcement jurisdiction at sea. Of course, Security Council is not a judicial body, and I understand that this is the topic of today. However, given the topic of the panel, I felt it would be interesting to look into its actions and its contribution to the effectiveness of this principle of peaceful use of the sea that is included in UNCLOS. Interestingly, there is a great paradox here. In applying this principle and protecting international peace and security at sea, Security Council is actually derogating from some core principles of the Convention. Why? Because Security Council provides sometimes states with the title for intervention when the law of the sea does not authorize such action. When implementing these resolutions, UNCLOS parties may derogate from the wording of the Convention. So it could give rise sometimes to disputes, especially I'm thinking of one dispute in particular that we will talk about later, the Rosa Line. And we do not have disputes in front of UNCLOS tribunals yet, but it is happening in other forums, for instance, before the European Court of Justice. So that's it for the introduction. I really want to tackle the problem now and come back very quickly on the legal basis for UN Security Council action very shortly. After that, explain the types of maritime resolutions that exist, which categories can we find, to give examples of derogations that were granted by UN Security Council and the limits of them. So first, of course, the legal basis for UN Security Council action is Chapter 7 of the UN Charter, when the Council identifies a threat to the peace. And this is where it is interesting to link my presentation to the one of Professor Tanaka, because using the wording of Article 39, the Council has sometimes applied this article to crimes at sea and to law enforcement action. Well, and in these resolutions, Security Council uses the sentence, the classical sentence, allowing the use of force. I put it on the slide, but of course you all know that. The member states are authorized to use all measures commensurate to the specific circumstances. I could identify two types of maritime resolutions, two distinct categories. The first one is what I call the first generation maritime resolutions, which are classic resolutions using traditional tools available to the Security Council, for instance, sanctions, embargoes. So the situation that constitutes a threat to the peace is a land-based situation. And the sea is just used to contain or to maintain the land situation. So maritime issues in these kind of resolutions are incidental. These type of resolutions are more and more numerous. They were very rare at the beginning of the life of Security Council and the life of the UN. And since the year 2000 and further, these maritime resolutions were adopted more frequently. But we will see that the scope also was limited, more limited. So some examples of these kind of resolutions, maritime resolutions. In the context of the Yugoslav conflict, Security Council has adopted Resolution 820 in 1993, authorizing member states to intervene in Yugoslavia's territorial sea in order to implement the embargo. More recently, Security Council has adopted resolutions authorizing states to implement arms embargoes, oil embargoes, or also proliferation measures adopted by Security Council. So these concern the situation in Libya, in North Korea, or in Iran. The second category of maritime resolution adopted by Security Council, what I call the second generation, was born after the year 2000. And to me, it is a new practice that reflects a radical change in approach by the Security Council, because these resolutions no longer deal with the maritime repercussions of a land-based situation, but now the link to the sea is more direct. It is these resolutions were adopted with the main purpose to protect the sea and to protect its security. So the direct objective of these second generation resolutions is to fight against crime at sea in general. So we have resolutions concerning piracy and armed robbery, illegal fishing, migrants trafficking, drug trafficking, etc. So in some of these resolutions, the Security Council will authorize states to derogate from certain rules of the law of the sea beyond the classical mechanism of collective security. So we are not talking about embargoes anymore. Part of a new approach then, aimed at overcoming the limitations of the law of the sea and the limitation of UNCLOS. Two examples, of course, the armed robbery and piracy of the coast of Somalia from Resolution 1816, and of course, the following ones. And other example, the resolution adopted to fight migrants trafficking, Resolution 2240 that was adopted in 2015, that concerned the Central Mediterranean Sea, and of course the resolution that followed. So this is the framework. Now I wanted to give some examples of specific derogations that were granted by Security Council to protect the peaceful use of the sea in general. So on the high seas, Security Council has authorized states, foreign states, third states, to inspect ships that are not flying their flags, and also sometimes to seize and dispose of prohibited items that could be found on the foreign ships. I put some examples here, especially the inspection to enforce an embargo or sanctions. So you have references here to the resolutions on Libya mostly, and also to fight traffics like crude oil traffic or human trafficking. The interesting point here, according to me, is that these resolutions, the last ones, impose upon the state that is intervening to make a good faith effort to obtain the flag state consent before inspection. So we will see that at the end of the presentation that this is the consequence of an evolution. But what is interesting here is that the resolution is just giving this obligation of making good faith efforts to obtain the flag state consent, but without further precision or further explanation on what is a good faith effort. And here we have some interesting issues on interpretation of this good faith effort, and especially on the delay that the state have to respect before intervening. For instance, the EU has implemented a practice of waiting 4 hours after the request for authorization to the flag state and the boarding of the vessel. Sorry, not the boarding, but the intervention, the beginning of the operation. The EU, in, for instance, the Rosaline incident, was implementing Security Council resolutions on arms embargo against Libya. So the Rosaline was a merchant vessel flying the Turkish flag, and she was sailing from a Turkish port to a Libyan port. The EU force there was Operation Irini, which is the name of the task force put together by the EU. And the Irini operation had the reasonable ground to suspect that the Rosaline was acting in breach of the UN arms embargo. Therefore, an Irini asset asked for the permission, well, the Irini headquarters, sorry, asked for the permission, the authorization of Turkey, flag state, to intervene on the ship. 5.5 hours later, Turkish authorities hadn't responded. Then the Irini headquarters authorized an asset, it was an helicopter, to undertake the inspection of the Rosaline. 13 hours later, while the inspection was in progress and nothing was found on the ship that was prohibited, Turkish authorities protested the boarding, and they said, the Turkish authorities said that it was a violation of international law, of customary law of the sea, because of the violation of the exclusive jurisdiction of the flag state, sorry, on the high seas. But also, Turkish authorities said that the 4-hour rule in the assessment of the good faith efforts was not a good rule, and they contested the interpretation made by the EU, and that this 4-hour rule was a fabrication of the EU, and that the delay was really too short for the Turkish authorities to be able to respond. So this is an example to show you that sometimes it is difficult to conciliate the derogations granted by the UN Security Council and the basic principles of the law of the sea. Other example of derogation granted by UN Security Council, and these are really rare, but they did happen. Sometimes Security Council had authorized the entrance, in the territorial sea of another state to conduct law enforcement operations, for instance, to enforce sanctions. This was Resolution 820 concerning former Yugoslavia, or Resolution 1816 concerning armed robbery at sea in the territorial sea of Somalia, here with the consent of Somali authority. The last point that I wanted to make is the limits of the recourse to Security Council as a legal solution to implement this peaceful use of the sea principle. Why? First point is the nature and the purpose of Security Council. Of course, Security Council is not a legal body, it is a political one. And as a political body, we always have the problem of political will of its members, which leads to a problem of foreseeability, consistency of the resolutions that are going to be adopted. The second issue linked to the nature of the Security Council and its purpose is that, of course, for the Security Council to adopt a resolution, it has to identify a threat to the peace. And of course, we cannot say that every illegal activity at sea will automatically threaten international peace and security. The second limit is the limitation of the derogation themselves. Security Council did adopt some derogations, but they were always limited to specific areas. For instance, the derogation that was adopted for armed robbery and piracy off the coast of Somalia was not applicable to other places and other locations where we had similar situations. For instance, the Gulf of Guinea. Same thing for the derogation that was granted for migrant smuggling in the central Mediterranean Sea. This derogation, of course, does not apply to other parts of the world where the problems are similar, like in the Caribbean Sea or now in the channel between France and the UK. Furthermore, of course, these derogations are limited in time. They are granted for 6 months or a year, and they need to be renewed by Security Council after that. And it is always difficult to adopt a resolution in Security Council because of the political issues and the political will of member states. And the last point that I wanted to make is to enlighten the evolution of these maritime resolutions. They are more and more numerous. So one could think that Security Council is more and more granting derogations to the basic principles of the law of the sea. But it is not the case. It is true that these resolutions, these maritime resolutions, are more and more numerous, but they are also more and more limited in their scope. The first generation maritime resolutions are a good example of these two parallel movements. More and more resolutions, but more and more limited. For example, the resolutions that were adopted for Haiti or Sierra Leone, or of course for Yugoslavia, were general resolutions with a general scope, with very wide powers given to all states. So the states had the power to board and search on the high seas all vessels that were heading to Yugoslavia or sailing from Yugoslavia. And they were also able to enter the Yugoslavian territorial sea to proceed with these inspections. So it was a very broad authorization and a very broad derogation to both the sovereign rights of the coastal state in its territorial sea and the exclusive jurisdiction of the flag state on the high seas. More recent resolutions are more limited and make a clear reference to the flag state and to the rights of the flag states. For instance, the resolutions on Libya concerning embargoes, armed embargoes or oil embargoes, but also in the resolutions concerning proliferation, the resolutions on North Korea or Iran. These resolutions contain derogations to the rule of the exclusive jurisdiction of the flag state on the high seas, but they are also more limited than the one that were adopted in Yugoslavia, because they require the states to seek the authorization of the flag state before their intervention. And this is the issue that we talked about when we discussed the Rosaline problem. The second generation maritime resolutions are also limited in their scope. These resolutions were adopted more recently by Security Council, and they reflect a cautious attitude on the part of Security Council, taking care to limit the scope of the derogation that it grants by using the famous customary exemption clauses that are inserted in all these resolutions, saying that the resolution cannot affect the rights or obligations of member states under the law of the sea, under international law of the sea, and that these resolutions shall not be considered as establishing customary international law, and that they cannot be used by member states to, well, in other contexts. To conclude, I just want to add that the recourse to Security Council has been a useful solution sometimes to tackle specific issues at sea and to give effectiveness to this general principle of the peaceful uses of the sea. However, the implementation of this resolution gives rise to international disputes concerning their articulations with UNCLOS and, of course, customary international law of the sea for the Rosaline incident, for instance. And the most interesting topic, according to me, is the interpretation of the good faith effort to obtain the consent of the flag state. As a result, it is interesting to look closely at the European pending case to see how the European Court of Justice will articulate the law of the sea and UNCLOS, the convention to which the EU is a member, is a party, sorry, with the Security Council resolutions. And maybe we'll see this articulation could give rise to a dispute in front of any of the UNCLOS tribunals. Thank you so much for your attention, and I'm really looking forward for the rest of this conference today.
Thank you very much, Dr. Neri, for a very interesting analysis of the evolution of UN Security Council resolutions and the increasing reference to maritime issues. I'm particularly interested in the 4-hour rule you mentioned, which is a very basic rule developing in terms of enforcement, but is also very controversial. I thank you also for your conclusions and highlighting possible trends in the future. It was a very interesting contribution. Thank you.